It's a great pleasure to appear before the City Club.
Join us, ask questions, and talk to the people who make New York what it is.
A New York City tradition.
Welcome. I'm Mindy Stern, President of the City Club of New York, and I welcome you all to another one of our public policy forums. The City Club is the city's oldest good government, nonpartisan, not-for-profit organization. Our mission is to ensure that New York City's government is helping make the city a better place to live and work. We carry out our mission by a variety of advocacy and educational programs. The cornerstone of our educational programs is the weekly public policy forum, like the one that you're watching tonight. In addition, we have a number of committees, standing committees and ad hoc committees that focus on such issues as education, the environment, land use, criminal justice, transportation, housing, and we encourage all of you here tonight joining us in person, as well as those of you watching on TV, to join us in our efforts, which you can do by contacting us if you're watching on TV at using the information that's on your screen. And here tonight we have brochures in the back. I'd like to turn now to tonight's program. As those of you who follow the club's activities know, for many years we've been focusing on issues that affect quality of life in New York City, but we decided that it would be interesting to discuss issues relating to life and death for a change, specifically capital punishment. Until a few years ago, New Yorkers were able to sit by complacently because we didn't have a death penalty, but in 1995, that changed. And the debate about the death penalty has recently heated up thanks to a variety of issues, among them death penalty moratoriums in a couple of states, and the issue being debated among a number of municipalities, including our own New York City Council, which recently passed such a moratorium. There's a U.S. Supreme Court decision that bars the execution of the mentally ill, and I hope someone on the panel tonight will explain how they're about to execute someone who is mentally ill in Texas. I was reading about that in the Times this morning or over the weekend. There's also the likely need to deal with terrorists and the cost of administering the death penalty. We have a very esteemed panel here with us tonight to discuss these issues and to introduce them and to moderate our program. I'm pleased to introduce Norman Green. Norman is immediate past chair and a current member of the Association of the Bar of the City of New York's Committee on Capital Punishment. He's also a partner at Schuman, Updike, and Kaufman, a New York City law firm. And he graduated from New York University School of Law in 1974. He has put together quite a number of very interesting panels dealing with capital punishment for the Association of the Bar of the City of New York, including ones with such interesting titles as Governor Ryan's Capital Punishment Moratorium and the Executioner's Confession, Views from the Governor's Mansion to Death Row, and that featured Governor Ryan himself, along with the president of the American Bar Association, Martha Barnett, and one titled The Condemned, the Tinkerers, and the Machinery of Death, Capital Punishment in New York Before 1965. Norman has also participated in death penalty training seminars, and by that I assume, Norm, you don't mean that you've trained people how to administer the death penalty. And he's also published book reviews on a number of death penalty books. So he obviously has a lot of expertise in this area. And frankly, it was his passion. I confess that he is a partner of mine in our law practice, and it's his passion for this subject that prompted me to think that it would be a worthy subject of a City Club forum. I'm delighted to turn the podium over to him to introduce our speakers and to moderate the program. Norman?
Thank you, Mindy. Thank you also to the City Club for having us here on this important subject. Mindy mentioned two programs that I've done with our Committee on Capital Punishment The one with Governor Ryan is published in the St. John's Law Review, and the one on death penalty before 1965 is going to be published in the Criminal Law Bulletin imminently. So it is available for those of you who weren't there. Welcome to Capital Punishment Under Siege. Where are we as a society going with respect to the death penalty? After some remarks, I'm going to introduce the panelists. But first, I'm going to give you some of my thoughts. One of the goals I have for tonight is to help give the audience and the TV audience the tools to approach the issue of the death penalty and how to think about it. I've had many conversations with people on the death penalty, and it's surprising how many really have any tools to deal with it. For example, you might ask someone, how do they feel about the death penalty? And you might hear something like this: well, I'm against it. And then you might say, why? And then you might hear silence, or something which is not much better than silence. Or you might hear someone say, I am for it. And again you might ask why, and again you will hear silence or something not much better than silence. If you speak to some people enough, you may find out that some who thought they were for it are really against it. And those who thought that they are against it really have not thought through why. And perhaps we can try to fix some of that tonight. Well, first let me address the title. Is the death penalty under siege? How can it be under siege given the horrible news that we're getting these days? Snipers, terrorists, the massacre at Wendy's. How can this be under siege? Well, of course it's under siege. I will refer to a number of events. One Mindy mentioned is the moratorium in Illinois on executions, which has been going on for a couple of years. The moratorium followed the exoneration of about half the 25 inmates that were then on death row. Counting Illinois, there have been over 100 death row exonerations. That means people who were convicted and sentenced to death who did not do the crime. When Governor Ryan was speaking at the City Bar Association, he made it very clear that he didn't consider himself to be a hero when he suspended executions in Illinois. His comment was more like this: well, we have 50% of the people on death row who didn't do it. What am I supposed to do? What is a person in all common sense supposed to do? Beyond that, we have a moratorium in Maryland. We have advisory moratoriums, and I say they're advisory because they don't have binding effect throughout the country, including in New York City Council passed last summer. There are also a number of advisory moratoriums in the city of Buffalo, Rochester, and a number of towns in Westchester County. They teach us what's right, but they do not have the power to implement the moratorium. There's been a study by Columbia University's Professors Liebman and Fagan and others who have found a high rate of reversals in capital cases, a good deal of which relate to subjects like law enforcement misconduct. By that I would include prosecution and police, and on the defense side, incompetent assistance of counsel, both of which do not allow a conviction to stand in many cases. There have been 2 federal court decisions holding the federal death penalty law unconstitutional. One has been in Vermont just this year, and another has been in the Southern District of New York, both for different reasons. The Supreme Court has held against the execution of the mentally retarded, and has also issued another decision just last term invalidating death penalty in certain cases where the judge makes certain findings as opposed to the jury. I've listed about 7 or 8 items, and I would say at this point, yes, there is a siege indeed against the death penalty. The word siege came from the decision in the Vermont case where the federal judge himself said that the death penalty is under siege. All right, let's look at the language we're using tonight, starting with the words the death penalty, capital punishment. I've thought about these words a lot, and they strike me as colorless words. They don't even begin to describe what really happens. They're almost euphemistic. And how we name things affects how we think about them. And the colorless words are matched by an invisible act. We kill people behind closed doors. It didn't used to be that way. The death penalty was once on public view, on scaffolds and gibbets and bloody and repulsive. Now it is indoors, but the same results. And I'm not suggesting that there's been some debate that there should be perhaps public executions. I don't happen to believe in it. I don't think it's a good idea. I'm just observing. So, but let's consider what happens even today. What is the result? Well, if you think about death penalty, and what we can contribute to this debate. My friend Bill Earlbaum, and you'll hear from him later tonight, and I always believe that it's important to make people feel what this is all about. What does it feel like to execute? What does it feel like to be executed? Well, we'll try with words. People will come to the cell of the condemned person about to be killed and tell him in one type of word or another that it's time, and then they take or bring or drag or do whatever is necessary to move him and strap him down so he cannot move and is helpless, and then poison him, if it's lethal injection, lying there. Make him stop breathing, hearing, feeling, smelling, seeing, remembering, recognizing, or knowing anything at all ever again, nothing and no one he loves, nothing he hates. So is this cruel? Well, if you consider what comprises death, and consider if we were to do each aspect one by one, who would not say that this was cruel and unusual? For example, if the sentence was only to render someone blind, or just alone to render someone deaf, or not that, just render someone senseless, and the like. And yet, if you do all at once, all of a sudden it's not cruel, it's sort of okay, and we call it a death sentence. The condemned is not a sick person, at least not physically, usually. Not a dying person, yet he is turned into a corpse in an instant and then buried. Now, this is not to take away from the horror of his crime. We are talking about what we're doing to the condemned prisoner. This is not an issue of what he did to his victim. And if you look at our criminal justice system, this is the only crime in our criminal justice system today, capital murder, in which society imposes the same consequence, death, as the criminal inflicts on the victim. In all other cases, society will generally respond to a criminal act with a term of years. You don't rape the rapist, and you don't burn the house of the arsonist, and you don't steal from the thief. This is the only exception, and you have to ask yourself why. Just in terms of a digression, with all the furor about the conviction of the innocent, what does it feel like to be innocent and facing the death penalty? Well, I guess if you were sitting in your cell, you'd have to say, excuse me, you're planning to do what to me and why? And what are these folks who are these innocent people who are on death row? What are they supposed to do as they're led away to execution? Be good sports? I mean, after all, they presumably receive due process, so what else do they want? Finally, attention to the death penalty is not a lonely study. It is one part and only one part of overall criminal justice reform. Reform over who should be sentenced to prison and who to treatment, over whether sentences are excessively long or too short, over prison conditions other than on death row, including opportunities for rehabilitation, and over ensuring that people emerging from prison may be safely introduced back into society, over parole, over clemency procedures, and over crime prevention. Death penalty gets all the attention, but death penalty is just one small part of our entire criminal justice system. After our presentations tonight, we expect that there will be time for questions. The first presenter will be Ursula Bentley, who is a professor of law who I've heard about for years from Brooklyn Law School. She is a graduate of 2 distinguished universities. She had a distinguished career at the Legal Aid Society. She now is, as a professor in Brooklyn Law School, is well loved by her students and teaches death penalty, among other things. She's handled many capital cases, and I'm delighted to be on the same panel with her tonight. So Ursula Bentley.
Thanks very much, Norman, for that introduction, and thank you to the City Club for inviting me and giving me this opportunity to talk about a topic that I have, as Norman has, thought about for many years. I'd be happy to answer questions later on any topic that's on your minds, but the one that I want to address in this presentation deals with costs. Mindy, when she introduced the program, said that usually the City Club talks about quality of life in this city. Well, I happen to think that the death penalty affects quality of life in this city. And it affects it very directly and practically by costing a lot of money. Now, it's not just about money. I'm going to talk a little bit because I don't think everyone realizes how much money it costs. Politicians who are eager to be very tough on crime don't tend to tell you what the price tag is for this toughness. But I'm not just talking about money. I'm also talking about time spent by all the participants, by the lawyers, by the judges like Judge Earlbaum, by jurors, by appellate courts, by the Supreme Court. I'm also talking, though, about, and time, of course, translates into money, so it's really part of the same thing. I'm also talking about the emotional toll that having a death penalty takes on everyone who gets in touch, who is in touch with this system. The victims' families, the defendants' families, and a topic that I've studied in some detail recently, the jurors. The jurors who were involved in sentencing defendants to life or death. The final cost I want to address this evening deals with us as a country in the world. And many of you probably know that the United States is one of the few developed countries, industrialized countries, that still uses the death penalty. Now, why do we care about that we are alone? Surely we can be right? It costs us, though, in two ways. It costs us because countries that do not believe in the death penalty are refusing to cooperate with us when we need their cooperation. And it also costs us, finally, in terms of our image in the world. We who are supposed to be the great defender of human rights. So those are my four brief topics that I want to address, all under the rubric of what this costs us. Let me start with the money. Somebody might say, somebody who's in favor of capital punishment might say, what are you talking about money? If this is the right thing to do, then what difference does it make how much it costs? Well, there are a lot of things that are the right thing to do. Certainly medicine, education, the environment, cleaning the environment, they're the right thing to do, right? Does that mean we don't consider how much they cost? No, of course we do. So I think it's not fair to say the cost shouldn't matter. Somebody else might say to me, well, are you really saying that if it were cheaper, it would be okay with you? And of course I'm not. But I think what that illustrates is the notion that, yes, it could be done more cheaply, right? Which I totally reject. It can't. And I think I'm going to explain to you why. Why is it that the death penalty is so expensive? And all the studies, of course, it's not that easy to figure out how much it actually costs. But there have been a number of studies, and they all come to the same conclusion. The death penalty costs more than life in prison without parole. There's no real debate about that. There is some quibbling about how much more. But the most recent study from Duke University, which studied North Carolina capital cases, found that having the death penalty added $2.16 million for each execution. Now, if you multiply, and North Carolina is not, they don't spend lots of money on their capital cases, but they're not at the bottom of they're not like Alabama and Mississippi where they do it really on the cheap. But they're not like New York and California that spend lots of money, so they're sort of in the middle, probably on the low end. So I think this estimate is probably conservative. And if you multiply that 2.16 million, and if my math is right, by the 800 some odd defendants whom this country has executed since 1973, you get $1.6 billion. Now, some would say, well, that's because there are these endless appeals, and we really need all these appeals? And people are on death row for 10 years before they finally get executed. Is all of this really necessary? Well, two answers to that. First, most of the money is spent on trials. And presumably, we want trials, right? And the trials take longer. The trials are more expensive if the death penalty is on the table. First of all, the defendant is not likely to plead guilty. So you're going to have a full-fledged trial, although sometimes you do have probably mentally ill defendants who do plead guilty. But most of the time you're going to have a trial. The jury selection, which normally takes, in New York, 2 or 3 days, sometimes less than that. In the first case tried in New York, the Harris case, it took months. In the Wendy's case recently, it took weeks. That means time of the judge, of the lawyers, and usually it's at least 2 lawyers on each side. In New York, sometimes it's 3 lawyers on each side, and they all get paid. Then the trial, probably the guilt phase trial, isn't all that different as if it were just life without parole. But then there's a whole other trial, the so-called penalty phase. And that can take weeks. And it can require experts on both sides. Prosecution experts to try to demonstrate that the defendant will be dangerous in the future. Defense experts to try to explain the defendant's behavior and to try to counter the prosecution experts. And experts, as you probably know, are expensive. Now, so if you do it right, quote unquote, it costs a lot of money, it takes a lot of time. So you ask yourself, well, does it have to be done that way? Do you really need all that time? I'll never forget the very first capital case that I became involved in. I was reading the transcript, and the transcript was very short. The entire trial took place in 1 day. This was in Georgia. Jury selection was in the morning. The prosecution's case went on in the afternoon. The defense put what case it had on in the evening. They summed up. The longest stretch actually was jury deliberation, which ended at 12:45 a.m. after a, quote, nervous juror. The foreman said one of the jurors is nervous. So the judge and everybody, the defense lawyer and the prosecutor, all agreed, well, let's replace that nervous juror with an alternate. And 3 minutes later, they had their guilty verdict. So now it's 12:45, and the judge apologizes to the jury and says, this is in a rural county in Georgia, says, I know this is later than folks usually stay up, but we still got to do the penalty phase. The penalty phase was 2 lawyers talking for 20 minutes, about the time I'm going to be spending with you this evening. And at 2 o'clock in the morning, the jury decided that this defendant should be put to death. You can do it that way. If you do it that way, what does that cost you? Well, it costs you what Norman already describes. It costs you the risk of putting innocent people on death row. It also costs you the risk that you're doing it after an unfair trial, that 2/3 of death sentences in the Liebman study, 2/3 of death sentences were reversed on appeal for significant legal error. Can you live with that? Is that okay? Even if you get the right person, he did it. He's not factually innocent. And even if you do the trial right, pay attention and the lawyers are doing their jobs, on what are you basing your decision about death? What a lot of studies have found is that the decision gets based on whether the victim is white, whether the defendant is black. Are we really willing to live with those kinds of mistakes? And if we're not, what does that mean? That means we have an appellate process that tries to fix those problems, right? Well, that's more money. The New York Court of Appeals there are 7 judges on the New York Court of Appeals. Each and every one of them has a special extra clerk hired specifically to handle death penalty cases. We're pretty new at it here in New York. In California and Florida, the Supreme Courts of those 2 states spend more than 50% of their time reviewing death sentence cases. Those are costs. And if we don't want to have on our consciences a lot of error, a lot of discrimination, a lot of arbitrariness, then those are costs we simply can't avoid. Let me finish this section of my talk with a quote from a Texas prosecutor, not a person you would think would say anything that I would want to quote, but here he is. This is Norman Kinney. I don't know if I'm pronouncing it correctly, the Dallas County DA. Even though I'm a firm believer in the death penalty, I also understand what the cost is. If you can be satisfied with putting a person in the penitentiary for the rest of his life, I think maybe we have to be satisfied with that as opposed to spending $1 million to try to get them executed. I think we could use the money better for additional penitentiary space, rehabilitation efforts, drug rehabilitation, education, and especially devote a lot of attention to juveniles. This is the prosecutor in Dallas County. Okay, let me talk a little bit about the emotional toll that the death penalty takes on people who have anything to do with capital cases. I see my time is running low, so I'm going to talk very briefly only about victims' families and defendants' families. Victims' families, who a lot of death penalty supporters would say that's who we're doing it for, the families of the victims. Well, first of all, we're doing it for the families of a very few victims. And the victims whose families, are not at the death penalty table start off being sort of minimized. And once the death penalty is on the table, it means if your crime, if the crime that resulted in the death of your loved one, the DA doesn't think it's worth seeking a death sentence for, well, what is this? Already, I am not worth as much as another victim. Even victims who are in the position of having a prosecutor seeking a death sentence in the case, not all of them favor the death penalty. There was a recent study that came out, a report, very moving report, about victims who are against the death penalty and how badly they're treated in court because they're supposed to be gung-ho and rah-rah. And finally, this sort of idea that victims get a sense of closure when the defendant is executed really has been demonstrated time and time again simply not to be so. What capital punishment does is to shift attention from the crime to the punishment. And that really doesn't do the victims' families any good. Defendant's family, I think it goes without saying, there are a lot of innocent people. Fathers, mothers, sisters, brothers, children, who, as Norman described it, who will watch or know that their loved one is being taken, dragged, etc., to that execution chamber. But the people I want to talk about for a few minutes are the jurors. There's a thing called the Capital Jury Project that's run out of Northeastern University, and I spent some time there a few years ago. And what folks there did is to interview jurors who had sat in death penalty cases and had arrived at either a death sentence or a life sentence. And there are many remarkable things about what these jurors say years after this experience. But let me just name a couple of them. One is, many of them have nightmares and are still anxious, not about the crime, but about their decision to impose a death sentence. Many of them, and two were actually mentioned in the newspaper this morning regarding this man whom Texas wants to execute on Wednesday, even though everyone agrees he's mentally ill. These two jurors said, and this is quite common, they said, you know, we thought he'd be out in 10 years. Nobody told us that he would have to serve at least 40 years in prison if we gave him a life sentence. There's a case that actually went to the Supreme Court of the United States, and I don't think you'll often see this in a Supreme Court opinion. But the dissenting opinion describes what happened in a particular case in Virginia. The jury was given the verdict form, and they had a question about it because it seemed to them from the verdict form that it was telling them that they had to give a death sentence if they found a certain fact to be true. And they didn't understand that, so they went to the judge, asked a written question, said, is it true that if we find X, we must sentence the defendant to death? The judge said, you have the written instructions, just read them again. Obviously, the instructions were not clear. What Justice Stevens in his dissenting opinion describes is that at the time the verdict, the jurors deliberated for 2 more hours, came back eventually with a death sentence. And the court reporter noted in the minutes that a majority of the jurors were crying. They thought, and several of them submitted affidavits when this man's clemency hearing came up, they thought they had to sentence the defendant to death. There are no doubt jurors out there who sentence somebody to death and who have since discovered facts, either that the law wasn't as they supposed it, as in the Weeks case, or facts about the defendant, that he was mentally retarded, that he was mentally ill, that he had a gruesome upbringing. One juror that was interviewed said that the defendant was, his father made him killed and made him eat his pet rabbit. You just cannot imagine the miserable lives some of these defendants have had. And jurors, sometimes, if they know that that's true, jurors will respond to that. Okay, the very final cost. Internationally, No country in Europe, not Russia, not Estonia, not Hungary, not Romania, not Canada, not Mexico, not most of Latin America, not Mozambique, not Senegal, not Namibia, not even South Africa. None of these countries still impose death sentences as punishment for crime. Now, why should we care about that? It's costing us. It's costing us in cooperation. It's costing us in the Moussaoui case, where Germany has explicitly said, we will not turn over evidence to you against this man as long as you are seeking to kill him. And that's going to happen with other suspected terrorists. There's no doubt about it. Another sort of practical effect of our isolation and our insistence on this penalty, despite our most countries that we are allied with, abolition of the penalty, is the possibility, which is being discussed in parliaments and other governing bodies in Europe, and in companies that trade with the United States, the possibility of economic sanctions against states that insist on doing this. Those are possible costs. The final cost I want to talk about is the cost to our own self-image. We are, at least we think of ourselves as champions of human rights across the world. And yet, we are one of 7 countries that still execute juveniles. Not only do we execute juveniles, we fight with one another for the chance to execute this juvenile who's involved in the sniper killing. What are the other 6 countries? The Congo, Iran, Nigeria, Pakistan, Saudi Arabia, and Yemen. Not even China, which is the major executioner in the world. Not even China executes juveniles. When the United Nations voted overwhelmingly in April of 1999 in favor of a moratorium, a worldwide moratorium on the death penalty, who dissented? The United States, China, Rwanda, and the Sudan. Is this the company we want to be in? I would propose a moratorium, but I would propose a moratorium not like the one in Illinois and in Maryland that's trying to fix this, because I don't think it can be fixed. It can't be fixed. So my moratorium proposes this. Unless you, who want to continue this practice, can tell me what's on the other side of the ledger, what are we getting for all these costs, we should stop. Thank you.
I would feel uncomfortable in this entire debate if I thought that people who were against the death penalty were also against punishment, if they were also not concerned about victims' families, and they were not concerned about the public safety. Well, I think all responsible people who are against the death penalty have to have in the forefront of their mind public safety, crime-free environment, and the care of victims' families. And I think as you listen to people tonight, you will not see anything different. This is not a soft on crime issue. You will see many prosecutors, ex-judges, some current judges, wardens, conservatives, religious leaders, public officials of all sorts who have undertaken to oppose the death penalty, and cannot be tarnished at all with issues of soft on crime. And let me just move to our next speaker because we're running a little bit short on time. Our next speaker is Bill Earlbaum. He is an acting justice of the Supreme Court in Queens County. He is a longtime criminal law practitioner before he reached the bench. He is an adjunct professor of law at Brooklyn Law School and an adjunct professor of political science at York College of the City University. He is also a member of the Capital Punishment Committee of the City Bar. Bill?
Thank you, Norman. And my job has been made easier tonight because of the three presentations that have taken place already. So I will simply skirt those areas that have been discussed and simply adopt them because there's nothing that was said tonight that I would quarrel with. I might say that the decision relating to the execution of the mentally ill, I think the decision that Mindy was talking about really had to do with the Atkins case forbidding the execution of the retarded. I don't know of any broad rule that forbids the execution of the mentally ill. If someone is not competent to stand trial, a very narrow issue, whether they know where they are and the roles of the major players and the ability to make rational choices, whether to plead guilty or not to plead guilty, or whether to pick a certain juror or not. Competence is an issue. If you're not competent, you don't stand trial. And of course, on trial, you can raise the defense of not responsible by reason of mental disease or defect. But that's a very exacting test in almost all jurisdictions. And you can be quite loony and be found competent to stand trial. Let me start with a disclaimer. It's essential that I do that. I do not speak tonight as a judge. The judge is that other fellow back in Queens. I speak as a member of the community, a student and teacher of the law and of political science. And that all I'll say about that, not to eat into my time too much, is it's a distinction that's well understood. Now that judges can serve on juries. When I'm on a jury next time, I'm a juror and not a judge. Tonight I resume my duties as someone's husband and someone's father. Here I'm a speaker, not as a judge. That's very important. I doesn't tell you how I would vote on any issue that would come before me. The death penalty under siege, I agree with the enumeration of the signs that indicate that indeed it is under siege. There are many such signs. 2 federal judges in 1 year striking down the federal death sentence on different grounds. 2 major Supreme Court decisions, one dealing with the retarded and not being subject to execution. The 4 judges' willingness to revisit the issue of the execution of juveniles, the European tradition, the famous Fagan report, and there's much more. One can flesh this out in great detail, and I'll be glad to discuss that privately or give you an email address if you like. Norman's point about a helpless person on a gurney, I think that's truly an important observation to make, as basic as it is, going back to basics, that we are dealing with a helpless person at that moment, quite literally. Even if we're Adolf Hitler, at that moment we are dealing with a helpless person strapped to a gurney. Another aspect that I think in making public policy decisions we have to realize is that that person is being killed on a standard less than self-defense. Only the state can do that. Less than self-defense. Nobody would suggest that the executioner is at risk of imminent harm in any way at all. He's shooting fish in the barrel, so to speak. So the state does that on a standard less than self-defense. Justice Brandeis many years ago said the government is the omnipresent teacher. It teaches by its an example. What an example indeed it is. Accordingly, the execution of a fellow human being in capital punishment is a gratuitous killing. In a fundamental cultural sense, that killing is un-American, because we have a strong tradition in America of not hitting someone when they're down. This is a person tethered to a gurney with straps, and indeed literally is down. And we are far more than kicking, actually killing someone who's down. And the way that killing is accomplished, I don't mean just the methodology of death, poison, as opposed to an electric chair or a gallows or a gas chamber, but the nature of the killing is a ritual killing. It is as much a ritual killing as anything that has been described in the human relations area files over at Yale. It is scripted down to the last comma. There are death protocols. And when people look back in this era, and I hope that we survive to a future age when one can look back at this era, they will describe, this will be seen as a ritual killing. As far as mental illness is concerned, while the law gives scant protection to that in terms of limiting the attack to incompetence or raising the defense of not responsible by reason of mental disease or defect, very narrow offenses. The fact is, if you look at mental illness in more common sense terms, and the Bible in this area, or at least one of the well-recognized Bibles, is what is called DSM-3, the Diagnostics and Statistics Manual of the American Psychiatric Association, DSM-4, the fourth version. The people who inhabit our death rows in America are very seriously mentally ill people. The fact is that's characteristic of prison in general to a lesser extent. Now that the mental hospitals have been closed down to a large extent, many of those folks end up in our prison system. It's got a fancy name called trans-institutionalization. They have psychiatric units in the major prisons encompassing 20 to maybe 60% of the population. In the death row area, on the death rows, you have people who are truly psychiatrically bizarre in terms of psychiatry, in terms of standard conceptions of mental health or mental illness. And in a certain cultural sense, that too is un-American, whether we appreciate it or not. Nazi Germany killed defective people. It is not perceived in terms of our own self-image that we are a country that kills defectives. But when we put someone to death, we are putting in general, and to a vast degree, a mentally ill person, a mentally deficient person to death, something which is inimical to our projections of what kind of society we have. Indeed, the studies that have come out in recent years suggest that it is harmful to the executioners. I'll simply say there's a literature on this. Remember the case of the bombardier who flew the Enola Gay over Hiroshima and the kind of personality decomposition that took place in future years. A human being is hired and paid a sum of money and told, you'll come to the prison on this night. We'll keep you quite busy if you happen to be in the state of Texas. New York, before Furman against Georgia, had a fairly strong stream of executions as well. It was second only to Virginia. That was many years ago. Texas now has given us about 35% of our executions in this country. And an executioner is told to come to the prison and probably paid in cash, I would imagine, and is told you're going to have a couple of jobs. You might get a third, but we're wondering whether there will or will not be a stay. I wonder how that is reported on one's tax returns. I wonder how one manages that personal identity. Is it a good thing from an ethical or moral standpoint to have a human being do that kind of work? Does it produce brutalization of that person and brutalization of the community? Remember the government as the omnipresent teacher. Indeed, I couldn't agree more as to the destructive effects of execution upon the judicial system. We have cases where a defendant or a family or a crisis situation is given 5 minutes of judicial time. I have 4 streams of cases that I generally handle. One of them includes domestic violence felonies. In this area, 5,000 women a year lose their lives. There's a tremendous amount of recidivism. It's a very dangerous area. The courts have scantily enough time to deal with an analysis of those cases. Such an extreme amount of energy is deployed in the execution process that those resources are indeed diverted away. Another aspect of this is that the death penalty tends to generate prosecutorial misbehavior. How very tempting it is to indict for a capital felony to gain some strategic advantage, to push a plea bargain because a person will not want to suffer the death penalty and will plead guilty even in a more marginal case. Look at the case of Andrea Yates in Texas just a few months ago, who killed, I believe, 5 children, and the prosecution filed a death notice. By the strategic benefits of filing that death notice was that the prosecution could get a so-called death qualified jury. That means in picking the jury, they could get a commitment from the jurors that they were capable of rendering a death sentence. Empirical studies suggest that those jurors who can live more comfortably with the death penalty tend to be jurors who are organized to convict. When it came to the penalty phase in that case, the prosecutor didn't put in a scintilla of evidence, but they got their conviction. Her defense was clearly a defense of mental illness, and she would have had a much better chance with that defense had she stood trial before a jury that represented a fair cross-section of jurors rather than a death penalty-oriented juror. And that was a prosecutorial ploy that we used in that case. Indeed, we can understand the anger that people feel toward perpetrators. Crime victims feel terribly disrespected. I've observed that. It's my 24th year on the bench. I was a criminal defense lawyer for 17 years. Crime victims feel disrespected. Of course they are angry. Of course they are, some of them have feelings that are vengeful, and others indeed do not. There are groups like Murder Victims for Reconciliation. There are people like Bud Welch in Oklahoma City that was against execution. And as Professor Bentley points out, some of them are marginalized and not considered true victims if they're against the death penalty. But basically, public justice is not private justice. The courts cannot do for the families of crime victims, whatever they would want to do privately. One cannot speak to the family of the victims and say, do you want a piece of him? What do you want me to do to him? The argument that Gregg versus Georgia majority opinion announced, that's in 1976. If you recall, in 72, a case named Furman knocked out every death sentence in America. There were maybe 650 people on death row. It didn't knock it out absolutely. They couldn't get an agreement that the death sentence was inherently cruel and unusual. It left the door open. Within 4 years, 6 more cases came up to the Supreme Court, and courts started to reenact the death penalty. When the case of Gregg v. Georgia reached the court, the rationale given was that we have to do this to these perpetrators. We have to, because if we don't do it, we will have vigilantism. Vigilantism. We'll have what you had with the lynchings and things of that sort. I suggest that it's a terribly immoral, a terribly improper rationale and a great stain on the concept of due process. Does that mean that what the court owes to the community is to treat the community as a mob, so to speak, like in the case of Leo Frank, where community people sat virtually in the windows of the courthouse and said, kill the Jew? Are the courts supposed to now bring in that kind of revenge and do it on behalf of the community? Indeed, there is a relationship between the death penalty and vigilantism. You see that in South Africa. They've abolished the death penalty in a very, very inspiring way. However, they have a very, very high crime rates and rising, and a great deal of vigilantism, and that is no answer. There must be no vigilantism outside of the courtroom or inside the courtroom. I think what I'd like to do now is just conclude on this point and leave it open to comments and questions during the later period and in maybe private discussion. This issue of victims, I also would like to say something about it. At the end of the Clinton administration, President Clinton granted a stay to Juan Raul Garza. And then that brought us into the Bush administration. In order to gin up support for the death penalty, Attorney General Ashcroft pushed this McVeigh execution, even though 4,000 pages of documents were missing. The fact of the matter is that very little is really done for crime victims in this country, except sentimentalizing it. Aside from a lot of this talk about closure, the reality is very little money is given to them. No one sends their children to college. Vast sums of money are indeed spent for the death penalty. It takes very little money to save a human being. The money that can be spent, for many better purposes, and it can be spent at the international level, as the World Health Organization tells us, and UNICEF. You can take just a few pennies and save someone's life. The fact of the matter is that crime victims often can be very, very compassionate. A lot depends on the way the prosecutor interacts with the crime victims' families. That's not an area that's been studied. It requires much more study. What are those interactions between prosecutors and families of crime victims? Some prosecutors perhaps take a very laissez-faire attitude. Others are scrutinize more. Thank you very much.
Bill, while you're up there, why don't you see if you can take a question or two?
Sure.
No time?
We have 1 minute left. Unfortunately, we only have 1 minute left, but I hope that people here tonight will stay and ask questions after the televised portion of the program ends. Please join me in thanking Professor Ursula Bentley, Attorney Norman Green, and Judge Bill Earlbaum for a wonderful presentation. To remind our viewing audience that you're watching the City Club of New York's Public Policy Forum, and we hope that you'll join us for the next one.